So I'm speaking with Professor Renee Knake, Professor of Law at the University of Houston Law Center and 2019 Fulbright Distinguished Chair in Entrepreneurship and Innovation. Renee, thanks so much for speaking with me this morning. You published your book, Shortlisted, Women in the Shadows of the Supreme Court, earlier this year. Obviously, it's very, very timely and relevant. Could you talk a little bit about the book and your motivations for writing it?
Sure. So the book tells the untold story of 9 women who were officially considered by presidents for the U.S. Supreme Court before Sandra Day O'Connor became the first female justice on the United States Supreme Court in 1981. This list goes all the way back to the 1930s. And so the first half of the book tells how these women, even though they weren't selected for the US Supreme Court to even be considered by a president for that role, you have to be selected for quite a lot. And so it tells exactly how they did that, the ways they moved into the legal profession. Many of them were the only women in their law school classes. All of them were told by their initial employers that they were trying to get jobs from, that they would not hire women. So how they navigated their careers to become highly successful lawyers and judges and beyond. And then the second half of the book takes those lessons and applies them to address the enduring inequality that exists in positions of leadership and power for women, whether we're talking about the US Supreme Court or across the legal professions, and sadly, not just in the United States, but around the globe, and actually in professional life. I think it's not going to be uncommon for any of your listeners, no matter what their field is, to be familiar with the phenomenon that women may enter a field of study or education or profession in numbers equal to men, but they aren't staying in positions of leadership and power. And so that's a big part of what the book tries to do. And in fact, we didn't really set out to discover this, but we identify a phenomenon of what it means to be shortlisted. The idea that an organization might be considering and trying to hold itself out as caring about equality and diversity by putting women on their shortlist, but then ultimately selecting someone who preserves the status quo rather than really attaining meaningful diversity. So that's what the book is all about.
And so were there any sort of personal factors that motivated you to write this piece and tell these untold stories?
Yes, so we have to think back a decade ago now, when President Obama appointed not one, but 2 women in relatively short order to the US Supreme Court. This was in 2009 and 2010. And he appointed Sonia Sotomayor and Elena Kagan, who still remain as justices on the court. In fact, at the moment, they are the only women justices on the Supreme Court because Ruth Bader Ginsburg just passed away. And my colleague, Hannah Brenner-Johnson, who is a professor at California Western School of Law, at the time we were working together at Michigan State University, and we noticed the media coverage of the nominations for these 2 women. And it was very gendered, focusing on the fact that they were single, who's going to accompany them to the fancy Supreme Court events, would they have a date, questioning the fact that they weren't mothers, focusing on their clothing. One article asked who wore it better when they both happened to wear the similarly looking blue blazer to their Senate confirmation hearings. And we just had not seen that same kind of gendered coverage when President Bush, a few years earlier, also put 2 justices on the court in relatively short order. Now our Chief Justice, John Roberts, and Justice Samuel Alito. So we actually looked at a media study. We looked at every article written by the Washington Post and the New York Times from the 1970s through the appointments of Sotomayor and Kagan. And this is thousands of articles, coded them for lots of different variables. And perhaps not surprisingly, we were able to show empirically that in fact the media focused more on gendered attributes for women than men. But what was even more interesting to us was an article we found amongst those thousands that appeared in the New York Times in 1971. And it was covering Richard Nixon's shortlist. At the time, he had 2 simultaneous vacancies. And he publicly released a shortlist with 6 names. One of the names was a woman named Mildred Lilly, and the New York Times reported that she fortunately had no children, and even in her 50s had maintained her bathing beauty figure. So of course that figured very much into the media study, but my co-author and I were like, who's Mildred Lilly? Why haven't we ever heard of her before? How many other women were shortlisted for the US Supreme Court before Sandra Day O'Connor? I mean, to that point in time, the only real story we knew about women on the US Supreme Court was the appointment of Sandra Day O'Connor. And so to answer that question, I spent time traveling across the country, going through presidential archives and private papers of the various women that we were able to identify. And as I said earlier, we found 9 women who were officially shortlisted, going all the way back to the 1930s.
So you mentioned in your answer, of course, the legendary Supreme Court Justice Ruth Bader Ginsburg just passed away a week ago Sunday. Could you tell us a little bit about why she was such a significant figure in the United States judicial system?
She was significant for so many reasons. The first, of course, is she was the second woman ever to go on to the US Supreme Court. And so that in and of itself was significant, to not just have one token woman on the court, Sandra Day O'Connor, but to also be moving forward to more of a critical mass, right? The appointment of the second woman. So she was significant for that reason. Her career leading up to that point had been completely devoted to championing equality for men and women. And at the time, she was actually considered a moderate choice when President Clinton put her on the court. And that was in 1993. But she would go on to become not just a iconic Supreme Court justice, but really a popular culture icon who is known the world over. I was really surprised when I came to Australia for my Fulbright to find out that Australians are just as big of a fan, if not more so, of the notorious RBG as we are in the United States. And so that also really contributes to the loss. It's very profound, both in terms of the makeup of the Supreme Court going forward, but also because she really had become a feminist icon. And even though she certainly, I don't think ever anticipated taking on that role, she had the ability to speak to generations after her in wanting to champion the very causes that she began her career fighting for, and that's equality for men and women, for everyone.
So why is her passing so significant, besides the fact that she was such a significant figure? Why is her passing at this point in time so significant in the United States?
Well, we have a Supreme Court that is quite conservative, and in fact, to say that Ginsburg was considered a moderate choice at the time in the early 1990s, and now, of course, her loss, she's thought of as one of the, if not the most liberal justice on the Supreme Court, shows you just how conservative the court is, because of what was once considered moderate views are now considered, sort of on the far left. And that matters for the makeup of the court, because we will now, if President Trump has nominated Amy Coney Barrett, she is a judge who currently sits on the Federal Court of Appeals, the Seventh Circuit. We have about 3 years of her judicial opinions, which, if we can glean anything, confirm her judicial philosophy, which she wrote about a lot as an academic, because she was a law professor before she went on the court. And she is widely known as a conservative who follows in the footsteps of her mentor. She clerked for Justice Scalia. And so she will be coming on to the court that has become increasingly conservative. And now we will be looking at a court with 6 solid conservatives, which means even if they disagree amongst themselves, and to be sure they will, because just because someone is liberal or conservative some of the time, or maybe even all of the time, doesn't mean they necessarily see eye to eye on everything. It certainly means for anyone who's making an argument that would appeal to the conservative group, it's a lot easier to find the 5 votes you need when you're looking for them from 6 people, rather than having to rely only on the 5. And previously, Chief Justice Roberts was sort of serving in this role where sometimes the liberals could convince him to come over to their side, and sometimes he would remain with the more conservative justices, and having that swing vote is really no longer going to be present on this court, at least as best we can tell. That's assuming that President Trump is able to have his nominee successfully confirmed. And because the Senate is controlled by the Republican Party right now, it's looking like that will go forward.
So when Justice Scalia sadly passed away in 2016, Republicans infamously refused to hold any hearings to confirm President Obama's nomination, Justice Merrick Garland. Their rationale at the time was a little inconsistent, but it essentially boiled down to we should not confirm a Supreme Court justice in an election year. We should let the people decide via their new president. Now, even closer to an election, only 42 days out.
Yeah, it's like an election month. It's not even the election year. I mean, not quite election month, but it pretty much is.
So obviously, a lot of people have, a lot of Republicans and Democrats have changed their tune, and their positions are now essentially the opposite of what they were in 2016, with Democrats demanding that the confirmation be delayed. And with Republicans insisting that they forge ahead before the election. So what are your thoughts on this rather abrupt change of heart on both sides?
Well, it doesn't surprise me, but my thoughts are that it makes me sad, because I don't like to see the Supreme Court politicized in this way. It's really supposed to be the branch of our government that is above the fray of politics. And looking back, now, I'm a critic of the selection process for the Supreme Court, in the sense that it took decades and decades and decades to get a woman on the court. And I think that there was a real lack of diversity, even though women were more than qualified to join the court. But one aspect of judicial selection for the Supreme Court that I do think is something worth reflecting on and remembering, and was something that was done well, is that previous presidents would look to the makeup of the court and try to achieve some sort of balance, whether it was with respect to geography or even religion. And even sometimes if a president from one political party had a lot of appointments, maybe even thinking about a justice who would be, ostensibly coming from another political party. Even as recent as President Obama, his appointment of Justice Sotomayor, she was on a lower court, a lower federal court, and she had been appointed by President Bush, a Republican. So it wasn't that long ago that the political appointment process wasn't so heavily politicized. And I think we have seen that in the extreme now with what Democrats would say was the stolen seat from Justice Merrick Garland, and now the very abrupt pushing through of who I think will likely soon be Justice Barrett. And I think that's unfortunate. There inevitably will be calls for reform, I think, in terms of how justices are selected for the US Supreme Court. There are certainly other ways it can be done, and it will be interesting to see what happens in our national election if the will of the people is that we no longer want to see these sort of extremes. Then if the Democrats control Congress and potentially the presidency, then we actually could see some meaningful reform in terms of how our Supreme Court justices are placed into their office.
So just going back to Justice Amy Coney Barrett, who President Trump nominated over the weekend, considering her political views, as you mentioned, or her personal views, and considering her relatively young age, and also considering that Supreme Court appointments are lifetime appointments, what do you think her confirmation, what consequences do you think that will have for the Supreme Court going forward?
Well, as I said earlier, it certainly impacts the balance, because she will be joining a court where the conservatives will be in the majority. And we have a number of younger justices who are conservatives. This is the third appointment by President Trump, for example. So we can assume, of course, you never know what's going to happen, but that it's very likely that Justices Kavanaugh, Gorsuch, and soon to be Justice Barrett will be on the court for decades. And that has the ability to change the outcome of decisions that come before the court, literally for lifetimes. And that's why I do think that we may see calls for reform and perhaps even the motivation to actually obtain that reform, whether it's term limits so that we don't have lifetime appointments, so either a mandatory retirement age or setting a term, say, of 18 years, to ensure that there's at least some turnover, so that as presidents turnover, there's the opportunity to also bring in new justices. There have been calls to increase the number of justices on the court. The fact that we have 9 is not something that's set by the US Constitution. This is something that's determined by Congress. It can change. This would not be the first time that a move like this had been contemplated. In the 1930s, Franklin Delano Roosevelt contemplated increasing the number of justices on the Supreme Court because he grew tired of the fact that the Supreme Court kept striking down his New Deal legislation. And in fact, the first woman who appears in our study, Florence Allen, she shows up on FDR's shortlist in 1937. I mean, I've seen the memo, her name's on the list. And it's precisely at the time he was thinking about increasing the number of Supreme Court justices. So it's sort of interesting as they're thinking, well, if we have more, maybe we could add a woman then. So this certainly wouldn't be the first time that there have been calls for reform. And it may be, now it wouldn't be calls for reform coming from a president who's unhappy with the decisions of the Supreme Court, but it would be calls for reform coming from members of Congress whose constituents are growing tired of the politicization of the court, or maybe also some of the future outcomes of decisions. I mean, I could definitely see if a future Supreme Court takes up an abortion case, for example, and maybe doesn't overturn abortion, but increases the ability of states to place greater and greater restrictions on abortion, that could be the kind of thing that we could see a legislative solution to in the future.
So just one final question. Do you think that the nature of the court, only having 9 justices, as you mentioned, the lack of term limits, and the fact that the balance of the Supreme Court essentially dictates the laws of the land of the United States. Do you think that all of those factors combined have led us to this real political polarization that we're seeing today, where the Supreme Court and judicial nominations are so cutthroat that they're forcing politicians further and further to the polls and exposing some of this almost rank hypocrisy? So do you think the nature of the court is one of the primary reasons that we're seeing this play out in this way today?
It's hard to know what the motivating influence is. Is the court just sort of reflecting the world in which it exists, or is the composition of the court part of the problem? And the answer to that is probably a mix of both. Although I will say, in general, like when we think about when the US Supreme Court is in its decision-making mode and it reaches a landmark decision, I'm thinking about Brown v. Board of Education, which ordered desegregation of public schools, for example. When the Supreme Court makes those big moves, it's generally reflecting the sentiment of the majority of the country. And so even though your question isn't really about a particular decision the Supreme Court is making, I wonder if it's really just sort of reflecting the polarization of political life in the United States as we see it now. I have a couple of thoughts about that. One, it would be very interesting in that regard if our presidential election ends up in front of the Supreme Court. It may. There's precedent for that. It happened when President Bush and President Gore were running. And of course, the Supreme Court handed Bush the election at the end of that litigation. All kinds of interesting questions there about whether or not Trump's appointees to the Supreme Court should then recuse if the election results are going before the Supreme Court. We could talk a long time about that, but I will tell you that the US Supreme Court is the only court in the United States at the state or federal level that does not have a formal or official set of ethics. There's no ethics code that they have to adhere to. So recusal would be up to the individual justice. The other observation I would make, I do think that what we're seeing with the Supreme Court is, and what I think we're seeing in political life in this country right now, is how important it is for each individual citizen to understand who's representing them at the local, state, and federal level. And just to go back to remembering Justice Ginsburg, she taught us well what to do if the outcome of a decision from the Supreme Court is not what we think is fair or just or right. And she did that through her dissents, which is part of what, especially in the past, say, 10 years or so, has made her so legendary, her fiery dissents. And one of her best, most important, and the one that I think is really critical for our country, but probably your country as well, to take some lessons from, is when we are unhappy with the decisions from our courts, we can go to our representatives. And in a case involving equal pay, a woman named Lilly Ledbetter received a substantial jury verdict because she had been paid less than her male counterparts for decades working at Goodyear Tire. And the US Supreme Court overturned that. And Justice Ginsburg was mad. She wrote a dissent, she read it from the bench, which happens very rarely. And she told Congress, fix this. And you know what Congress did? And the first bill that President Obama signed into law when he became president was the Lilly Ledbetter Fair Pay Act. So that's, I guess, the thing that gives me some comfort at this crazy time in American democracy, that there is never just one way. And even though it may mean progress is slowed, because to be sure, getting a bill passed by Congress can be more time consuming than getting a court to rule on a matter, there's ever more always an option and an ability, a third way to move this country more toward the promise that it was built on, which is a more perfect union, one where we will all be equal. The documents that set that out at the time did not include, I couldn't have voted, for example. It didn't include equality for a lot of our country, but we operate under a framework where whatever we're thinking about our various branches of government, whether they are functioning as they should, or they're overly politicized, or maybe even a bit dysfunctional, that we can turn to each of them as needed and keep moving our country forward.
Some really profound words to end on. Professor Renee Knake, thank you so much for speaking with me this morning.
Oh, it's been a pleasure. Thank you.